Benjamin Stram. Yeah, I wanted to also say something that's a bit along the lines what Daniel Loick just told us, and I think it is true when you stick with usus fructus as a Roman law concept, then I think you're running into troubles, because there it is after all a concept of Roman property law, and the thing that the salva rerum substantia, that requirement, it's a duty towards the owner that the usufructuary has towards the owner, and so vis-a-vis the owner. So it's the owner who actually sees to it that usufructus is being that you know the duties of the usufructuary towards the substantia, that it's being upheld. And there's actually a huge amount of legal doctrine that the Roman jurists piled up that tries to kind of delineate the border between what the usufructuary can do, and it's a lot that he can do, and what the owner's remaining rights are. And there it's interesting to see that the usufructuary is actually usually perceived, there's a conflict of interest obviously, and the usufructuary is the one who's perceived as having short-term interest in maximizing his benefit. It's the owner that has long-term interest. So if you applied that to your model, then of course you would want to have an owner who actually sees to it that the long-term that there is some long-term benefit from the substantia, from the thing. So to do away with ownership on that usufructuary, on that model of usus fructus, I think has at least, yeah, in that the Roman doctrine would suggest that you might run into problems with it.
Maybe you would like to address those comments that is coming together now.
Oh, and can I add something just about the justice and Cicero and property? I would suggest I wouldn't agree with you. I would just say Cicero would say, well, it's actually unjust to violate private property. That's what justice is all about. So he talks a lot about justice, but he would say that we have the state in order to maintain private property in the first place. I think it's De Officiis 273, but I'm not sure.
Yeah, I mean, first of all, thank you for your very generous comment. I mean, obviously, I'm not a specialist in these issues, and so I'm very grateful that you provided the context for me. I'm well aware of the fact that the Roman jurists were not about ethics were not their main concern, let's say. I wanted to have a concept that is somewhere in between. That is legal. That I wanted to have a legal concept in order to be able to. I mean, a lot of these discussions about global justice and about how should we put constraints on individual state actors only have either other state institutions or merely moral or natural right resources. So I wanted to have a concept that is, on the one hand, a legal concept, but on the other hand, able to somehow circumvent the problem that we impose a property regime on someone. But this, I mean, if we go one step further and think about how to institutionalize something like that, of course you have all the problems that you hinted at, namely you need a system of advocacy. You need somebody who speaks for the absent third, and in this case, for example, the owner. And then you run into all the problems that we had in the first session already, that Jean Cohn and Lorenzo were pointing at, paternalism and the lack of agency and so on. I mean, all concepts of advocacy have these problems, but I think this is a way of somehow reconciling the moral or natural rights claims within a legal order. So I was excited when I found the concept of usus fructus precisely because it was a legal concept and not an ethical or moral concept. but I see all the problems that come with it. Don't you want to have an owner that is interested in the long-term substance of a thing? Yes, I mean, you cannot do away with this idea of ownership altogether if you adopt a concept of usus fructus. I mean, usus fructus just doesn't make sense if you have nobody that this trusteeship relegates to. But in this idea, as I was trying to sketch, the idea of common usufruct, the figure of the owner is only a figure of thought, so to say. It never occurs a situation where you actually somebody has ownership rights to something. It's never the case that ownership rights and the owner are the same, and that is why I think that these problems that just the one usufructuary takes all the benefit out of it is that such a situation can never occur, because you're always responsible to a third, and the third might be succeeding generations, but also in principle absent third parties. And you have this idea of responsibility and other regarding obligations built into the very foundation of your political order, without it ever be the case that it can be revoked by an actual owner, as somebody who is an actual, person or institution or so.
Comments? Sandy?
Thank you very much. I think it was a very interesting paper, especially I like the part that talked about imposing a property regime on people that don't conceive their relationship to land as property. But I have two comments on your concept of property. I think that property, like sovereignty and trusteeship and many other legal concepts, are essentially contested terms. And the way you present property is only one understanding of property. And other ways to understand property includes duties toward others that are very strong, bona fide, and many concepts that present a very atomistic vision of property, which I think is just not correct even today. I mean, it's even not the major or leading concept of property. The other comment is on your vision of constraints. Constraints can be neocolonial just as the opposite. You have, for example, conflicts between indigenous people and states, where the indigenous people right now want to utilize the land in a way to make a living, and the states are trying to retain them in their fossilized, museum-like situation of 200 or 300 years ago. So this is also can be neocolonialism.
Yeah. Yeah, I mean, the first part, I agree. I mean, I abridged the whole genealogy of property to an almost irresponsible degree. I mean, obviously, there are a million constraints to property, and they played out to a different degree in different historical situations. And this is already actually in the quote, in the Proudhon quote, you're only allowed to do whatever you want with your property as long as it is within the law. And I mean, there have been, and there are right now, you cannot do whatever you want with your property. But I still think...
outside the law. It's within some concepts of property say that within the concept of property itself, there is a limitation and it is to other. It's not only imposed from the outside by the law, but it's part of the mere concept of property.
Well, I would still defend the view that property as such has this idea of rejecting outside intervention. I mean, that you cannot...
This is one conception of property.
Yeah, but what other conceptions would there be?
Hanoch Dagan, for example, who is here in this law school, talk about, or Joseph Singer at Harvard Law School are talking about looking at property as something that includes both duties and rights. And it's a socially constructed concept, and you can build it the way you want, and there are discussions about it. You present just one vision of it, that's all.
Right. I mean, okay. I would argue I presented the vision that is dominant and that is put into practice in a very long Western legal tradition, and you have this. The whole idea of private right is that there's something private about it, and that is precisely what also guarantees the freedom of it. I mean, I can, if I want to have. If I want to buy a bottle of booze, and you don't like it, then it's your problem. I can do whatever I want, and that is what guarantees my freedom. But also, it enables me to reject all other moral and ethical considerations. And a way to mitigate this dissociative element in property relations is to have strong political institutions that, for example, govern or that are able to promote a certain understanding of society and so on. And that is, my sense is that while you have that in a nation state, or could at least in principle have it in a nation state, it is very hard to conceive of such strong political institutions on a global scale. And if you would, it has other problems too. So I think the whole idea of property has this, at least as I conceive it, has a rejective tendency, which is not helpful if we would want to think more creatively about our future. The second question, constraints can be just as neo-colonial. Yeah, I agree with that. You have situations where subaltern actors are basically forced into a situation where all the options are bad. You have to struggle for rights even though you didn't want to be a legal person in the first place, or if you don't do that, you lose everything too. But the question is, on what point occurred the more fundamental violence? And I think we are used to think that the violence occurred when we took somebody from them. But also it includes, in my opinion, imposing a property regime in the first place. And but I agree, like in the current situation, you have to decide maybe case to case.
Take two comments. No, few. You don't know? Yeah. Okay.
No, this is just a very short note. You mentioned the locatio conductio or lease as another type of contract. No, as actually you have two institutions, usus fructus as a real right and locatio conductio as contractual right. Okay, and I go back to the issue of the locatio conductio because this is where you have a lot of material which actually aims at exactly getting to what you want. Carefully defining the rights and the limitations of the holder, which is in that case the lessee, but it doesn't matter. It could be also the usufructu arius, vis-a-vis the property of the owner and the property. Let us say what types of plants can be cultivated, and it is actually, this is what makes lease contracts in general one of the most complicated and most interesting types of documentation, because it is ongoing aim at redefining and reestablishing, clarifying the mutual positions and exactly protecting aiming at protecting the rights of the owner. So this is just something that you could maybe there are thousands of documents like this, both from the ancient Near East, from Greco-Roman Egypt, from within the Corpus Juris Civilis, and I think this could be a very nice experiment to try to see how what you find there fits into your thesis.
Yeah, thank you very much.
We'll take another comment. Yes?
Yeah, thanks very much, Evan Fox Decent. I think one of the challenges that you face is that the trust concept, at least as it's understood in the common law tradition, doesn't necessarily depend on property at all. The subject matter of a trust relationship may be property, but it may be something else. It may simply be a practical interest. And so when you talk about property having necessarily capricious side to it, that's true when one is exercising one's own sovereignty over one's own property. But that's never the case in a trust relationship. That's never the case. There's always obligations of care, of loyalty, of either regarding concern with respect to whatever is the subject matter of the trust relationship, whether it's conceived in usufructuary or strictly property terms. Now, one thing I was thinking that might be interesting as a contrastive concept, if that's sort of what you're looking for to contrast with property, rather than the usufructus, at least when we're thinking about land, is territory. Because whereas with private individuals, there are conventional stories about why property is helpful or useful to them. They need property to have means to pursue their ends and so forth, a standard Kantian line. We don't typically think the kinds of exclusive claims that individuals might make to certain property they need would necessarily apply to states, which have public territory that has a dimension that I think is quite different from the way we typically think of private property. So that's just a suggestion as a way to, if you're looking to still work a contrastive through a contrastive concept.
Yeah. Thank you very much, both of these suggestions. I have to think more about it. I mean, my first reaction to the territory suggestion would be that while it might avoid some of the problems that some you wouldn't be able to avoid with the territory. I mean, for example, the idea of colonial imposition to organize land as territory also has this implication maybe, and also the idea of or that it accustoms us to a certain perspective, maybe a domineering or masterful perspective of land that is unorganized by organizing it. It is a very deep social psychological, basically, hypothesis or speculation, you know, how we can relate to our environment in a more, in a way that promotes human flourishing more. I mean, you always sound a little bit romantic when you say something like that, but I think we shouldn't give up these kinds of ideas, and I think that the idea of territorialization of land might not be the best ally in this project. But I'm not sure. I'm going to have to think about it more.
We'll take 3 more questions. Lorenzo, towards David, and then Jim.
Thanks, Daniel. I really enjoyed the paper as a whole. But I have 2 comments about risks common ownership and the conception of usufruct you put forward. So on the one hand, I think that you're a bit ungenerous towards Rice's idea of common ownership, because you can well argue that the commonality of that ownership is quite an effective constraint against abuses of the property. You take the Boston Commons example. Obviously, the possibility of using this land is clear, and then of course the protection against abuse is somehow inbuilt in the idea of commonality. Nobody will allow for this abuse. Of course, you say, well, they don't really deliberate about the use, they don't have a common project, but even that perhaps is a bit too stretched in the sense that in the beginning they had to think of how to single out this space, and they had to deliberate to a certain extent on how to use it. So it's not completely free of deliberation. So, and I think that it could be rescued and presented as a way of constraining ownership effectively. And on the other hand, regarding the usufruct notion, I think that you're a bit too generous towards the Marxist interpretation of usufruct, and in particular when it comes to the proviso that Marx inserts, that is the boni patres familia proviso. I think that this comes back to my point on paternalism. So the boni patres familia comes with all sets of assumptions about what is a good father of a family, and also a whole set of assumptions about organizing property in ways that are inherent to a family setting. And this goes back to the original comment. So I wonder how you sort of rescue usufruct from this proviso that seems to be quite exclusive. Thank you.
David Shore, yeah, so just to follow up on that comment, and specifically about common property, I mean, I totally agree with you, first on the communicative idea, not only at the time of the setting up of the common property, but under, I mean, you know, common property is a very broad term which could include many different types of regimes. At least under some of them, there's actually a requirement for communication and deliberation throughout the life of the common property. For instance, there are rules about majorities and supermajorities that may have to make certain kinds of decisions. You may not be allowed to make certain kinds of uses without, you know, without agreements, or sometimes even unanimous agreement. So those kind of typical rules of common property institutions seem to get the kind of deliberation you're talking about. And also, to pick up on your point also about the abuse, you know, some views of common property actually are quite close to the way you're describing usufruct, in the sense that you can make use of the fruits, but the, you know, but the fund of the property, you can't, you know, that can't be touched. The common property owners can only use the fruits. And on both of these points, I would point you. You may not be familiar with Carol Rose's work, who's a property law scholar, who's written a lot about both of these issues, and specifically a lot in the context of environmental issues, which you also mentioned.
Yeah. You seem absolutely at ease with the concept of trusteeship, and you don't like the concept of sovereignty. I might be the reverse here. But I would just say that I think that just as we've seen that property, and you even mentioned it in the paper, the power of the paterfamilias was subject to a whole range of limitations, so it wasn't absolute. The same thing is true of the concept of sovereignty. I actually think that the notion of absolute sovereignty always was a myth. The reduction of sovereignty to sheer power was always an inaccurate description. I think there was always a juridical dimension to it, and that I guess generally, although, I mean, I think the historical analysis, even if it were right, I don't know if it's right or wrong, I'm not a classicist, but let's say it's right, I think that, I don't think Genesis is structure, so that it might be that certain concepts carry certain baggage, but it might also be that with certain very important transformations, the concepts themselves become freed of that baggage. So I think the question that we really face is whether we want to continue to rethink and elaborate, in this case, the concept of sovereignty, or simply abandon it. And as the point, as Benjamin Straumann made with reference to property, I mean, property is not identical to commodity in a capitalist market system. I mean, this is the basic point. And so just as the concept of property might have some rather positive connotations, I care about it. I'll keep it clean. I'll develop whatever. The same thing could be true of sovereignty, as we've seen with Ayal's paper as well, with reference to democracy. So I just want to throw that out there as a sort of. Although I understand the thrust of your paper, and I see where it's going. I would just my preference is rather to, as far as we can, rethink these concepts as long as they are actually out there. In the object domain, because sovereignty has not yet vanished from the perspective of the main actors, to rethink them rather than get rid of them from a perspective that might be moral or ethical, but not. Well, I'll leave it at that.
And if I just might add, from an efficiency perspective, if you have a private property, you have both a right to exclude others and an interest to do so. If you move to a system of usufructus, I'm not sure who will have the interest to enforce the system, who will operate the fire alarms and call the cops to actually maintain this regime as efficient. So you have just a few seconds to conclude and then we can go to the coffee break.
That puts a very problematic motivation structure on. Oh. Well, I mean, okay, the first thing is I agree that certain models of common ownership might come close to this idea of common usufruct of the earth because they involve more communicative institutions than I would give them credit for, maybe. But not the one presented by Risse. He explicitly demarcates his own idea of common ownership from joint ownership. So there is explicitly no place for institutional deliberation about what to do with the Boston Commons or the earth. So that and he brings arguments for that. It's too a demanding picture of political institutions and so on. So, but in principle there might be other models. But I still think that the underlying imaginary of the idea of usufruct has this idea of taking care of a thing built into its own very structure, where the idea of property does not have that. And I would still say that. And I mean, what your last question, I think empirically, yeah, would be an interesting point to conduct some research. Who takes better care of their stuff? I think if you rent an apartment or if a friend lends you something or so on, you're very careful with it. And you have an interest of using it. And people, and I mean, the idea of the tragedy of the commons, for example, if you use something together, this leads to overuse. This, in my opinion, is really a tragedy of common ownership, that you are accustomed to treat something as if it was yours. And that this precisely leads to overuse and damage and destruction. And if we take into account that others want to use it too, then this leads to more careful, sustainable use. But I mean, I grant that this is a little bit speculative. And the whole idea of this paper was, when I read Risse's book, Common Ownership of the Earth, I was like, this is a horror vision. We as a humanity should be owners of the earth. And I was trying to somehow explain my discomfort in a little bit more abstract terms. Namely that the idea of relating to the earth, of the globe, in terms of trusteeship, does something to us, to our subjectivity and to the way we relate to each other. And it is really not that easy to explain what exactly is the mistake we make when we think of the earth as our property. But I think many of us actually do have that intuition, and probably I didn't do justice to it in trying to explain it. But this was basically a first attempt. I know I didn't address any of the questions actually, but I was just trying to explain or give a little bit more context to what I was trying to do.
Thank you very much, Daniel. We have a coffee break for 2 minutes.